Hello everyone and welcome to our webinar this evening. This evening iPlanGroup is presenting Don Pendleton. Don is the president of the Asset Protection Academy. It's America's premier training company on the topics of lawsuit protection, estate planning, and income tax reduction. He's been teaching asset protection for over 15 years and co-authored 4 books on the subject. He has an event coming up in North Carolina where we'll be joining him to help teach students about self-directed IRAs while he teaches everyone about asset protection. He's going to tonight do part 2 of asset protection for the real estate investor. So welcome, Don, and you have the floor.
Oh, Jill, it is always delightful to talk to you and your students, and we appreciate the relationship we've had over the years. And so I'm going to kind of get right into it without a lot of introduction. I am going to kind of go through a little disclaimer. Whenever we're talking legal and tax stuff, we can talk about general principles. How they relate to you and your particular situation is really something for you and your advisor to talk about. One of the great advantages of the 3-day summit is we have a chance to sit down with great tax attorneys and great asset protection attorneys, really good estate planning attorneys, and go over your particular situation, kind of draw up a blueprint and how these principles apply to you personally. But to take these and assume that every one of them will fit in your situation would probably be unwise. And then this is just a small sample of what we'll be teaching at the 3-day Asset Protection Summit. Let me go up here, if I can go up. We've got one. The next one coming up is in Charlotte, North Carolina, in 3.5 weeks. So if you haven't made reservations for that and you'd like to, as part of iPlanGroup, Jill, we've made arrangements with Jill and iPlanGroup to waive your tuition. Tuition for this event is normally $995, but as part of coming in through Jill and she appreciates you as a client, then we're waiving the tuition for you if you'd like to attend. It really is America's premier asset protection class. And Jill right there is featured as one of our presenters. We're delighted to have her, but we're also bringing in some of the best of the best of the best attorneys, presenters, trainers to teach this class. So again, we invite you to attend, but for tonight, let's talk real estate. We mentioned that this is part 2, and I wanted to take about 5, maybe 7 minutes and kind of review what we talked about in part 1, because a lot of you didn't have a chance to go back and do that or have a chance to listen to it. If you'd like to listen to it, you can always write iPlanGroup a quick little email, and they would be happy to send you the link to part number 1. But let's review a little bit about what we talked about. We talked about some of the sources of lawsuits, especially for real estate investors. We talked about 67% of all lawsuits that real estate investors are going to face are going to come from tenant safety and welfare. And that's a big one. That's a big one. But there's also management problems, maintenance concerns, joint and several liability. I told you that the scariest one of all for me is statutory liability. If they find a chemical spill or they find mold, mildew on the premises, there's no chance for a defense. It's simply, oh, it's there, you're going to clean it up, and those things are scary for apartment owners and for real estate investors. And so we talked about some of those fairly bluntly. We talked, let's see if we can get this thing to work. Well, I think we're going to start over. I don't know what happened. Sorry about my slide thing not working. We talked about the insurance dilemma, that it seems like the more you have, the more attractive you become. And we talked about what we consider to be an adequate amount of insurance. I'm not going to go over that in great detail, but we certainly believe in insurance. We want you to have good liability insurance. for whatever you're doing. That should be the first line of defense for a plaintiff's attorney. However, there are holes in every insurance policy. There are things that the insurance doesn't cover you, and that's why we do legal structuring. The problem is that you can have so much insurance that you become actually attractive to a plaintiff's attorney, and it actually tends to work against you. We talked about what is the very best legal structure for a real estate investor, and it really comes down, the premier question you have to ask yourself is, am I flipping or am I holding? Because the concerns are very, very different. The liability issues are very, very different, and thus the structure, the legal structure that we would recommend is very, very different. Holding is very different than flipping, again, because the concerns are different. The structure will be different. If you're holding properties, we always suggest a property management company and an ownership company. We talked about the tag team approach. The value of having both entities work in tandem. We talked about what states are very best to hold that multi-member LLC as a holding company. We talked about what does a management agreement do, and the value of shifting all liability up to a management company that doesn't really own much, but it's liable for everything. It's liable for all repairs and maintenance and tenant matters and safety and welfare, but the management company doesn't have a lot of skin in the game, doesn't have a lot, but by contract, we're shifting that. We talked about the duties of a corporation. We talked about the duties of the multi-member LLC. We talked about which one does which and how the accounting flows. I want to spend a little bit more time on accounting tonight. We talked about how do we protect multiple properties. Let's say in the example shown on the screen, there's 3 properties. Do I stick them all in one LLC? And the answer is, well, if I've got very, very little equity, yeah, that would be a good option, is to stick them all in one. If I've got a lot of equity in them, or maybe they're in different states, then I might use multiple holding companies to hold the properties, but I can still manage it under one management company. We talked about how to simplify your taxes by using single-member LLCs when the single member is a multi-member LLC holding company. And so we talked about you could have 47 single-member LLCs, each one holding a separate property, but we still only have 2 tax returns, one for the management company and one for the holding company. And so we talked about the value of simplifying your income tax situation. We talked about what states the entities ought to be filed in. We told you that the single-member LLCs that hold the property should be in the state where the property is located. The multi-member LLC, the holding company in the middle, that hub, probably should be in a state with really, really good charging order protection, like in Nevada or Wyoming or Alaska, Texas, South Dakota, some of those that have really great charging order protection. And the property management company needs to be licensed to do business wherever properties are being managed. Okay, we talked about that in pretty good depth, and we talked about how to tax each one of the entities. Normally we take a property management company, tax it as a C corporation. The multi-member LLC, that hub in the middle, we tax as a partnership, and the single-member LLCs we tax as disregarded entities. We talked about the value and how to tax those in different situations. We talked about if that holding company now is a self-directed IRA instead of a multi-member LLC, the value of having a third-party property management company so you're not engaging in prohibited transactions. And even if you're using the example where we're using, I don't know, maybe multiple self-directed IRAs, again, the value of having a third-party management company manage that so that you can have hands off and you're not engaging in anything prohibited. So that's kind of a bulk of what we talked about last time. I hope that wasn't boring. We covered a lot of ground as I went through and reviewed this and kind of put together this little slideshow. I thought, wow, we covered a lot in 45 minutes. In the next little while, I'd also like to cover a lot of ground, but we want to leave the last 15 minutes open for questions. And so let's kind of jump into part 2 of how real estate investors protect their assets. And we're going to go fairly fast. I'm not a fluff teacher. We're not going to use lots of stories and examples. I'm kind of a crowbar kind of style teacher. Here's how we do it, and without maybe as many explanations as we're going to get into at the 3-day summit when there's a lot more time to teach. So I hope that that's appropriate. So why do we use limited partnerships and multi-member LLCs? And remember, whenever we're talking asset protection, I'm talking multi-member LLCs, not single-member LLCs. I'll explain that in a little bit, why that's important. And before we do that, let me show you a slide. Let's suppose you had everything in your own name, in joint ownership, maybe you and a spouse, or maybe it's you I don't know, you joint ownership, or you own it as a sole proprietorship. If everything you own, and your investments, your savings, your real estate, your home, everything's in your name, the mother of all lawsuits comes, and a lawsuit results. You know, something happens in your personal life. The question is, can they take all the assets away? And the answer is, yeah, they're pretty much toast. Well, what if I had everything set up as in my living trust? See, the living trust is really a probate tool, but because of the fact that it's revocable, I can amend it, I can change it, I can move assets in and out and in and out. Because you have access to those assets, a judgment creditor against you, in most cases, would also be able to rip into anything in the living trust. That's not to say living trusts are bad. We tie everything eventually into a living trust, but we normally use limited liability instruments, like, again, limited partnerships, multi-member LLCs, first, which are then owned by the living trust. So living trusts are not bad, but for good asset protection, we need a layer in between. What if I had everything set up as a sole proprietorship? Well, that's really just you, and so yeah, the mother of lawsuits comes and they take your assets away. Well, what if I had everything set up in a corporation? Well, okay, a corporation is a separate legal entity. So if you do something wrong, in theory, the corporation didn't do anything wrong, and they can't take the assets out of the corporation. But the corporation has one inherent weakness, and that is who owns the corporation. Well, in most cases, especially in S corporations, you have to own that stock personally. And most people do own stock in their personal name. And so if you own the stock and you get sued and somebody comes in and takes the stock away, then they own the corporation, and all your investments and savings and everything is gone. And so corporations are a wonderful tax tool, but they're not a good asset protection tool because of the vulnerability of the stock. But let's suppose that I had everything in well-structured family limited partnerships or LLCs. Again, the mother of all lawsuits happens, something happens in your life, creates a lawsuit, you're accused of doing something wrong, or maybe you did do something wrong. Can they attach to the assets in those limited partnerships and those LLCs? And no, they can beat against those little buggers all day long, but they can't attach to the assets inside of those. The only legal remedy that the judge is going to allow in almost all situations is he would allow a charging order to be placed against those limited liability instruments. Well, okay, so what is a charging order and how does that work? Well, the LLC, let me go back here a little bit and explain that. A charging order allows them to the judgment creditor to take a percentage of the assets. In all cases, that's zero. You can't take the assets out. And if you understand a little bit of the reasoning why, way back in 1916 when limited partnerships first started in America, let's say there are 5 partners that come together and they go in on a real estate deal. They get going, they're involved for 2 or 3 years, and then one of them gets in a lawsuit. What happens is the other 4 didn't do anything wrong. You can't just come in and take the assets out of the limited partnership because that would hurt innocent parties. And so it's been the law and it's been the court decisions, not only the state statutes, but it's also been the court decisions over and over and over and over again, is you can't take the assets out because it would hurt the innocent victims. So what happens is the judge says, well, you can't take the assets out, but you do get the distributions if they're distributed. Which means, let's say there's $100,000 of income at the end of the year in this limited partnership or LLC. You're standing there, you've got a 1/5 ownership interest, so in theory you'd get $20,000. A charging order, what that means is that their hand is on top of your hand. They get the distribution instead of you. But it's only that which is distributed that gets. Now we come into not state statute, but now we look at J. Mitten's limited partnership. J. Mitten was the first attorney in the nation to start using limited partnerships. LLCs hadn't even been created at that time. And he started using great little clauses inside of a limited partnership. For instance, let's say in your limited partnership, this is not, by the way, we don't use Real Quick and Family Lawyer or LegalZoom or anything prepared by most estate planning attorneys, real estate attorneys, litigating attorneys. We're looking at clauses that have been created by asset protection attorneys. According to the American Bar Association, I told you this last time, less than 1% of the nation's attorneys specialize in asset protection. We want somebody that looks at every case where a limited partnership or LLC is broken or under duress, and then we want clauses in there that just make the operating agreement or the partnership agreement just absolutely tight. For instance, let's suppose you had somebody put a charging order against your limited partnership, and you've got a clause in your partnership that says something like this: the partnership will distribute its available funds at least annually, but it's only after the creation and restoration of all such reserves as the general partners deem as reasonable to operate the partnership. So in other words, you're standing there with a spigot, and I can turn off distributions or I can retain them. And you go, you know what, next year I've got to put roofs on the houses, so we're not going to distribute anything. Next year there's a great house that I want to buy, or there's an opportunity, so we're not going to distribute anything. And you're standing there with a spigot. Somebody puts a charging order against your partnership, and you get to distribute or not to distribute, but it's the general partner's discretion. Let's suppose there were a clause in your partnership that said, oh, by the way, the general partners may, in their discretion, distribute the profits and or capital of the partner pro rata or non-pro rata as they deem advisable, which means I can distribute to partner number 1 and 2 and 3, but not to 4, but I will to 5. And all of a sudden, they can distribute to the partners that they want to. If somebody has a charging order against them, they may choose not to distribute to that partner this year and see if the judgment goes away. Let's suppose that somebody came along, there were a clause in your partnership that says, you know what, I could still distribute to partner number 4 for fees or services rendered to the partnership, but we're not going to call it a distribution. We're going to call it a fee or a service. Let's suppose that there were another little clause in there that says I could still borrow or lend money to partner number 4, but again, we're not going to call it a distribution. It just has to be on terms acceptable to the general partner, which is probably going to be you, from any person or entity as long as it's consistent with the best interest of the partnership, as determined by the general partner. You see, the flexibility that we can build into this agreement, it gives the general partner or the managing member tremendous flexibility. So let's suppose, again, somebody puts a charging order against your limited partnership, and you have the ability, because of so many unique clauses, to be able to shut them down and say, I'm sorry, we're not going to distribute anything. There are some really, really cool things in our limited partnerships that we teach at the summit, and how to structure limited liability instruments so that judgment creditors are put in a very, very bad position. Well, who would ever want to sue you if they knew that they're not going to get anything? And the answer is, well, probably they're not. So let's refresh. Let's say somebody puts a charging order against your limited partnership, and you have the ability to retain earnings, to distribute pro rata or non-pro rata, still compensate yourself for fees or services rendered to the partnership. You can lend or borrow money at your discretion. The mathematical question is, how much are you going to distribute? And the answer, of course, is, well, I'm not going to distribute anything. Thank you very much. So they're sitting there with a charging order against you. They get zero assets. They get zero income. And then comes along IRS ruling 77-137 that says, wait a minute, somebody has to pay the taxes on that $100,000 that was earned but not distributed. And that IRS ruling says whoever has the legal right to receive the distribution has to pay the taxes. Now, let me, while that's kind of kicking around in your head for a minute, let me give you an analogy that will maybe help you understand that. And that is, let's suppose that today, August 20th, we put $5,000 in a bank account. We just set it in a little savings account. We set it aside. We don't touch it. It's just $5,000. We set aside and we don't touch it. At the end of the year, you get a little 1098 statement from the bank that says, oh, you know what, here's the $13.21 worth of interest you earned on that money. Well, do you have to pay taxes on that $13.21? And the answer is yes, you do. That's interest income. Well, wait, but I didn't take the money out. It's just sitting there. The IRS doesn't care whether you took the money out or whether you didn't. The fact is, because you have the legal right to take it out, you have to pay the taxes, whether you distributed it to yourself or not. The charging order works exactly the same way. The IRS doesn't care whether you distributed or whether you didn't distribute. The issue is, if somebody has a legal right to receive that distribution and they're in a pass-through entity, they get to pay the taxes on money you didn't give them. So let's go back and remember joint ownership, where they get to take everything away from you, or sole proprietorships, or even corporations, living trusts. Let's compare that to a limited liability instrument, where somebody sues you. They can't take the assets, they can't take the income, and they get to pay the tax bill on phantom income that you're probably never going to give them. Does that sort of make sense why we use limited partnerships and LLCs? Well, yeah, because it puts you, the owner, in great position to now negotiate. Now, we do not want people to use limited partnerships and LLCs to hide. If you do something wrong, stand up and admit you did wrong and fix the situation. But all of a sudden, it puts you in a very, very good position to be able to do the right thing and settle the case. If you do something wrong, again, we don't use the limited partnerships and LLCs for wrong reasons. Bad people do use these entities. We never encourage that, but we do want to ward off anybody that's suing you for frivolous reasons and put you in a very, very strong position to be able to negotiate. I hope that sort of makes sense. So now, if you're going to do anything to do any asset protection at all, there's one concept that is often overlooked, and that is the difference between inside and outside liability. And so I wanted to spend just a few minutes on inside and outside liability because it's pertinent and it's critical that you understand this. Let's suppose that you've got all these assets tucked safely in a limited partnership, family limited partnership, or multi-member LLC. Something happens in your personal life that creates a lawsuit. Let's say an airplane goes down, you were driving, you're responsible, there's wrongful deaths. Okay, can they get to the assets inside of the limited partnership and LLC? And the answer is no. Those things are safely protected. The only thing that judgment creditors should be able to do is put a charging order against those assets. And again, this happened because it's a separate legal entity. There are other innocent partners involved that didn't do anything wrong. You can't take the assets out. Maybe they can put a charging order against your interest in the partnership, but that's about all they can do. They can't take the assets out. They don't get the income because of the partnership agreement that hopefully you will use. And it didn't do anything. That legal entity didn't do anything wrong. But you remember what happened is the lawsuit happened in your personal life. Let's change that around and say, okay, what happens if this apartment building, there's a fire inside of the LLC. Furnace blows up, kills several people. Now is everything inside of that bubble susceptible to the lawsuit? And the answer is yes, it is. Because, again, the nature of the lawsuit came from inside of the bubble, therefore it's very different than outside liability. So why would we as asset protection specialists ever suggest you use a legal entity that doesn't protect you from inside liability? And the answer is because there isn't one. It doesn't matter if it's an offshore trust or an irrevocable trust or a domestic trust, or it doesn't matter if it's an LLC or multi-member LLC. It doesn't matter what it is. Nothing can protect you from inside liability. So what we do, the solution is sometimes we use multiple LLCs and multiple limited partnerships. We'll talk about when to use which one in a minute. Limited partnerships, generally when they're safe assets. Generally we're using family limited partnerships to protect safe assets. Safe assets being there's no liability. It's a brokerage account. Your 100 shares of IBM stock are not going to run down the street, trip somebody, and cause an accident today. It's gold and silver and it's paintings and collectibles and things that inherently are safe. So it could be billions and billions of dollars, doesn't matter. You could stick all those in one legal entity as long as there's no inherent risk. But would you want to, let's say, put a vehicle inside of that billion-dollar limited partnership? And the answer is no. Because now you've introduced risk into that otherwise safe bubble. When we're using real estate, almost always we're going to use multi-member LLCs. Multi-member, remember, innocent victims, we want other parties involved in this LLC. And thus you have good charging order protection. Okay, so often, especially when there's real estate involved, we might consider using multiple entities. Now, let's go through the scenario again. The apartment building, a fire happens in the apartment building. 16 units, furnace blows up, several wrongful deaths. You're in the middle of a lawsuit. Is it possible that you can lose all of the equity in that one building? Yes. Well, hopefully you have a good management agreement. Hopefully you have great insurance. Hopefully you've managed the equity well. Hopefully a lot of things. But the worst case scenario in this situation is they can take that one asset away from you, but they shouldn't be able to take away any of the others. If you run this right and you've got really good legal documents, then the most they can do against those other entities is put a charging order against those, which, again, they didn't do anything wrong, and I'm not sure that in some of these situations that they would even be able to put a charging order against it. They're separate legal entities. And so, again, let's go back. The difference between inside and outside liability is huge. And I wanted to just spend a minute on explaining that. So the question then is, okay, if I'm doing real estate, how many limited partnership or LLCs do I need? And without getting specific and knowing each one of you individually, I don't know how to answer the question, but I can tell you that the 6 questions that I would ask you if I were sitting down with you personally. I can't give you specific legal advice, but I can give you the questions you would answer yourself. You test yourself on to determine how many LLCs and partnerships you need. Number 1 question is, what am I willing to risk? Well, I don't want to risk anything. I don't want to lose anything. But okay, but let's give you just kind of a scenario. Let's say I've got $1 million worth of equity in real estate. Okay, and I got 10 properties. Okay, what's the most you're willing to lose? Well, again, I don't lose anything, but if I lost a quarter of it, could you still bounce back? If you lost a third of it, would that be, I mean, we're asking really, what's your tolerance for risk? We want you to have good insurance. We want you to manage it right. We don't want you to commingle funds. We want you to pay your taxes on time. All of those things, but worst case scenario, what would you be willing to risk? And a lot of that has to do with your age. Sometimes people that are a little bit older and are near retirement are going to be a little bit more conservative. Those that have time to earn it again might want to risk a little bit more. But let's suppose, just pretend, I'm not suggesting anything, but let's suppose that the most I'm willing to risk in real estate equity is a quarter of it. So we would start with the assumption that we're going to start with 4 LLCs, wouldn't we? Okay, so but that's an important question. Number 2 is, how much equity do I have in each property? Well, if I've got 0 equity in 3 properties, I might stick those together. Could one property bring liability? Yes, it could. But I got very little equity, or I'm upside down in my Florida properties, so I'm going to stick them together. See, that might save me a couple tax returns and maybe still give me really good asset protection. So I would I would look at the equity that I have in each property and kind of separate them. I don't want all my eggs in one basket, but I'm separating the equity into maybe 4 baskets. Okay, so that's one way to look at it. Another way to look at it is, are there any properties that I have, of these 10 properties, that pose a significant risk to my estate? Okay, 9 of them are really good, but there's this one that's got an unfenced swimming pool. It's got reoccurring mold, mildew. It's got this butthead renter that I know is going to sue me. I don't know, whatever. You either fix the problem. Let me just be blunt. You either fix the problem, or you isolate that property into a separate legal entity and don't affect any other properties. Maybe it's time to get rid of it. Maybe it's time to solve the problem. Maybe it's just time to isolate it. Another situation you might consider, and that is cash flow. Because if you're a real estate investor, you know that cash flow is very important. If I'm living off the income from these properties, let's say 8 of them are kind of, they're after depreciation. Yeah, on paper they make money, but I've got 2 of them that are my cash cows. Would I really want to stick both cash cows in the same limited partnership or the same LLC? And the answer is no. I might want to separate those, just in the event that one gets sued. I don't want to affect my cash flow. Another thing I would consider is state filing fees. There are some states that charge a lot for filing fees. Michigan, I think it's $10 to set up a limited partnership and no annual fee thereafter. Ohio, I think, is fairly cheap and no annual fees. California, $70 to set up a business entity and $800 per year minimum tax due on each entity. Well, in Michigan, I might have more LLCs and limited partnerships than I would in California. So state filing fees are kind of important. And state boundaries are also important. If I got 3 properties in Tennessee and 2 in Kentucky, I might stick the 2 in Kentucky in one legal entity and save myself a couple tax returns. Again, those are the 6 questions that I would ask to determine how many limited partnerships or LLCs that I might use. I hope that makes sense. All right, so let's talk about how it really works with accounting. I told you I'd get to accounting a little bit later. And how do the legal entities kind of work together? And I want to leave some time for Q&A, but I also want to go over this. So again, we talked about having a property management company. This is kind of like the way Bill Marriott sets up hotels. There's always one to manage and one to own, and a management agreement that ties it together. To just have a corporation and then a multi-member LLC with no tie isn't going to give you good asset protection. But if you had a management agreement that said, you know what, the management company is responsible for all maintenance, repairs, tenant matters, all safety and welfare, all regulations, advertising, record keeping, bookkeeping, you're responsible for managing. If the insurance lapses, it's your fault. We're shifting all liability away from the equity position in real estate up to a management company that owns a desk, a chair, and a computer. You see, that's kind of the goal, is to shift liability. We do that through a very strongly worded management agreement. And then what we do is we set it with the corporation. We do that, and what it does is it operates, manages the business. It collects the rent. Picture, if you would, you just hired me to manage your properties. Okay, which might be stupid, but let's pretend I'm an outside property management company. Would you expect me to collect your rent? Well, of course you would. Would you expect me to deal with all tenant matters and all contracts and pay all the little bills? And you'd allow me to charge a management fee and then send you the rest of the money on a regular basis, maybe monthly or quarterly or something. But you would expect that. And so if you're going to do this and do it right, this corporation has to act as a true outside third-party management company. Otherwise, if you're not going to play the game, then all of this can be combined together, and the reason to have all the tax advantages of having the corporation, all the liability protection of having the multi-member LLC structure is kind of a sham. You've got to play the game, and accounting is a very, very big part of it. So what does the LLC do? Well, the LLC owns the real estate. That's what it does. And if let's go back to our scenario. You own the property, I'm managing it. Would you expect me to pay your mortgage? No, probably not. Out of the money you get, you'd probably pay your mortgage. You'd probably pay your taxes. Who pays the insurance? It could go either way. I don't know that really matters. It could be part of the contract that the corporation or the management company is responsible for that. So where does the money flow? In this situation, all the money comes into the corporation. It collects the rent. It charges its reasonable management fee, pays the little bills, sends everything down to the multi-member LLC. If there's a major repairs, it needs a new roof, you need to, dig out the sewer line or put in a septic tank or something, those are usually done by the owner, not by the management company. And so hopefully that makes sense. What this does, this structure allows you to zero out the corporation at the end of the year, send all the other income down to limited partnership, where it's considered passive by nature. So I tax percolate everything I can percolate out of the corporation. I deduct my medical expenses, I deduct my training, my education, I deduct, whatever you can do, send the rest of the money down to the LLC where it's passive by nature. Ooh, baby, this could be really cool. What happens if I'm using, so I could use this, if I'm using multiple LLCs, separating them again, I'm putting the baskets where, instead of having one basket, I've got multiple baskets, one management company, multiple LLCs. I could do it this way, or I could also do it another way, using single-member LLCs. But before we get to single-member LLCs, let me warn you of why single-member LLCs don't work in 45 states. They do work, but very, you have to be very careful. You can't be the owner of the single-member LLC, or you lose your charging order protection. I'm not saying they don't work, but you can't be the owner. We have to use another step. So let me tell you kind of why it doesn't work. In 2003, there was a landmark case. It was a bankruptcy case in Colorado. It was Mr. Albright had put a couple $1 million in a single member or a single owner LLC. A couple years later, things kind of went awry with his business, and so what happened is he declared bankruptcy. And he's standing before the bankruptcy judge and saying, look, you can't take that $2 million away from me because it's in a separate legal entity. And the only thing you can do is put a charging order against it. And the judge in that case says, you know what, the charging order was really created to protect innocent parties. In this case, because it's a single member LLC, there are no innocent parties. Mr. Albright, you got into debt. We're going to rip all the assets out of that LLC to pay the judgment creditors. And what happened in 2006? That was supported in an Idaho case. It was supported in a Maryland case. It was also supported, backed up in a Minnesota case. And in 2010, the Olmstead case came down. It was a very famous case where Olmstead, the Federal Trade Commission, was coming after Olmstead. He had a lot of money tied up in a single-member LLC, and the judge in that case says, you know what, single-member LLCs do not provide charging order protection. We're going to rip the assets out and give them to the Federal Trade Commission. As a result of the Olmstead case, and maybe the Albright and the other cases too, Wyoming legislature met in 2010. And they said, single-member LLCs are good in our state. Come to Wyoming. We'd love your business. And so it was kind of cool. And since then, Nevada, Delaware, South Dakota, and Alaska all said, you know what, single-member LLCs are good in our state. But the other 45 states have not said that. So here's what we do. If you're looking for simplification, let's go back to simplification. Let's say I've got 4 properties or multiple properties. We could put those in single-member LLCs as long as you are not the member. If you're the member, you're the member. You lose all charging order protection. But if this is held instead, so the property's in a single-member LLC, the single-member LLC is owned in turn by a multi-member LLC. Now, it's me and my wife, it's me and my partner, it's me and my best friend, it's me and, I don't know, but you have multiple parties now involved. Now we have charging order protection. I hope that makes sense. And here's the problem that I see is lots and lots and lots of accountants all over the United States don't get this concept. They're putting properties in single-member LLCs, not knowing that their clients have zero asset protection from outside liabilities. If something happens, you get sued in your personal life, and they'll come take these properties away from you. That's not why you're working all the hours that you're doing to become a real estate investor. You've got to structure either the way that we showed you before with multi-LLCs, or in this way, single-member LLCs held by a hub. In this case, what's shown on the screen, you could have 47 partnerships or properties, each held in single-member LLCs, held by a hub in the middle, and you still only have 2 tax returns. It's really cool way to do it, but the multi-member LLC is the critical thing, and that's where we would go to a state with really strong charging order protection. Nevada, Wyoming, Alaska, those are really the predominant states with great charging order protection. So with that, now could I use the same structure with the self-directed IRA? Absolutely. Same thing applies, whether that's a multi-member LLC in the middle or a self-directed IRA. Jill sets up for you, whatever. That's sort of how it works. All right. So with that, I'm going to go to the last slide. And again, remind you that this is just such a little sample of what we teach at the 3-day summit. If you're expecting to come to the summit, by the way, if you're registering for it, and you're expecting this to be like a wussy little 9-to-5 seminar, you're going to be shocked. We are serious asset protection geeks. It starts at 8 in the morning, it ends at 9 o'clock at night. Of course, we'll give you lunch hours and breaks and times to rest and relax, but we are bringing in the very best of the best attorneys in the nation. Law professors, there are at least 2 attorneys there that can take your case all of the way to the Supreme Court. These are the best attorneys that we can find anywhere in the nation to teach asset protection. So that's a little summary of what we do. Would love to have you join. Again, if you're joining through Jill's group, we're waiving your tuition, which is kind of cool, and hopefully we'll see you in Charlotte or in Las Vegas. So with that, Jill, let's open this up and let's answer some questions.
Okay, thanks, Don. If anyone has any questions, they can type them in the question box and I'll read them and we'll answer them. While we're waiting for questions, Don, I have a question about 3 slides back when we had 4 single-member LLCs owned by a multi-member LLC for charging order protection. My question is, if I had those single-member LLCs owned by a single-member LLC in Nevada, Wyoming, Alaska, does that give me protection?
That would work.
Does the holding company, that would work? Okay.
That would work because, again, single-member LLCs are recognized in 5 states. But if you tried to do that, let's say in Ohio, and I put that hub, that blue one in the middle, no, wouldn't give you any asset protection.
Okay.
Good.
I have one more question while we're waiting for other questions. The question is, you talked about the management company taking a reasonable management fee. I have a management company, thanks to you educating me. I seem to add a little layer every time and learn something every time I attend. What is defined as reasonable?
You know what? That's a really good question. And if the management company were managing, let's say, stocks and bonds, the IRS doesn't have any real guidelines. It has to be reasonable. So, Jill, let's play a game for a minute. That I was managing all your investments. Again, it would be a dumb idea, but let's play the game. If you ever pay me, let's say, 40% of all profits to manage your accounts.
I would not pay you that much profit even if you were excellent.
What if I were doubling your money 3 times a year? Then would you pay me 40%?
Absolutely.
So it depends. It depends.
Yeah.
If you pay me 40% year after year, of course not. It depends on what's happening. It depends on the situation. When it comes to liquid assets, it could be a fee. It could be, well, it's $400 a month to manage it. If that's reasonable, if that's a $10,000 account, oh, that's probably not reasonable. It could be based on the trade. I've got an account with TD Ameritrade. They charge like $10 a trade. Okay, it could be based on the number of trades. Could be the hours that I put in. It could be based on my experience. But it just has to be reasonable what you would pay an outside person to do. When it comes to property management companies, the IRS is a little bit more conservative. They have some guidelines. And most outside management companies for real estate would charge between 6 and 11%. You're in the real estate game more than I am. Is that reasonable? We stay within those guidelines?
Yeah, absolutely. It's around 10%. You're right.
So could I be on the high end of that or the low end? Well, yeah. If I'm going to go outside that, you better have a very good reason. Why? Well, okay. Look, but let me show you how flexible this can be, Jim. Let's suppose I'm in a growth stage of my life. I want I'm putting all the money on the table. It's like a monopoly. I'm putting every penny that I can on the table, and I'm building wealth. I'm young and healthy. I don't have medical expenses, and so my business are really, really low. I mean, I have cheapest property management, maybe 5% is all I'm deducting. But let's suppose I'm now at the end of my life. My wife has cancer. I've got a lot more medical expenses. I'm traveling. I'm doing a lot more things. And could my reasonable management jump up to 10 or 11 or 12% if there's a good reason for it? The answer is yes. Because I need more money in the corporation. I got more things to protect. I'm looking for more tax deductions. You see how this can be a little flexible?
Absolutely.
I'm overkill that, but
okay, we have one more question. Can my LLC be registered in a state that I don't live in?
Absolutely. But whenever I do that, I have to have what's called, well, anytime you set up a business entity, you have to have a resident agent. If you don't live in the state, you have to hire a resident agent, or if your brother-in-law lives there, your sister, or somebody. And let me give you. Okay, I don't live in Ohio. If I wanted to set up a business in Ohio, I would have to have a resident agent. A resident agent is a person who lives there. And first of all, it's a real live person. And the reason why is the marshal or whoever's going to serve me, if there's ever a lawsuit, they want to be able to walk up to a real live person at a real live address and be able to hand a summons to them and say, get this lawsuit to Don Pendleton, who lives in Utah. They don't want to travel all the way to Utah and find me. They want to serve papers in Ohio, because that's where the property is located. And so the qualifications then to be a resident agent is, in most cases, you need to be a real live person. You have to have a physical address, not a post office box, and you need to live there most of the time. Now, if you don't have somebody that you can, just do that, and a trusted person, then you can always hire a resident agent. Get online, do a Google search. There's resident agents in every state. Most of the time, they're going to charge about $100 just to be the resident agent. And what that means, they sit in their office, they collect the $100, they never do anything unless you ever get served, and then they get the piece of paper to you. It's like the most brain-dead job in the world, but that's a resident agent. And yes, you can get it in any state, and it will be required for all corporations, limited partnerships, LLCs, the business entities. But yes, you can set up your legal entities in other states you don't live in.
Perfect. The next question is from Robert. What are the filing fees in Wyoming, Delaware, and Nevada?
Nevada just almost tripled their filing fees. It used to be about $400 per entity, and now there's a business tax, and I don't know exactly what they are. I helped a client set up one in Wyoming. I think it was like $60, $70 to set it up, $50 a year to keep it alive. Alaska, I think it's about $50 to set it up, $50 a year to keep it alive. Again, that's you have to have a resident agent. Delaware is not really, Delaware is great for big corporations. I don't know that they have the very best LLC and limited partnership statutes right now. And so we would use a corporation, we would use Delaware if we're doing a publicly traded corporation because they've got great laws to protect shareholders. They don't have, I think Nevada has the very best laws for small corporations. When it comes to limited liability instruments, again, limited partnerships, LLCs, Delaware is probably not my first option, so I don't know what the filing fees. You can always go to the Secretary of State website. So do a Google search, SOS, Secretary of State, comma, Delaware, and you can find the filing fees. I don't know all 50 states off the top of my head.
Okay. The next question is, what if the multi-member LLC is just me and my wife? Does that protect my personal assets in the case where a property is held in a single-member LLC is hit with a major lawsuit?
Yes. Husband and wife create the multi-member. Now, it requires then that you be a little bit cleaner with your account. Because what a plaintiff's attorney is going to want to try to do is say, well, this is just an alter ego view. It's really just them. We want to go after their personal assets. They want to, if something happens in the property, they want to come after you personally. They want to pierce a corporate veil. If something happens in your personal life, they're going to want to try to take the assets away. That's charging loan protection if it's coming that direction. And either way, they're going to try to say, you know what, this couple's not playing the game. And so they're going to look at, did you pay your filing fees on time? Did you pay your tax returns on time? Did you commingle funds? Did you, I don't know, did you have your minutes and meetings and resolutions for a corporation? Did you play the game and did you do it right? And if not, then it's going to be considered an alter ego of you. They're going to rip apart your whole structure and it's not going to float. So when we're talking about these legal entities, it's not just important that you use really good forms and that you structure it properly, but it's equally important that you maintain it. But to answer your question, yes, husband and wife can be a multi-member, but you have to be just a little bit cleaner on your corporate formalities and stuff than if you had outside parties. If you had outside parties, it would make it stronger. If you had, for instance, a one-legged stool holds up. Let's say I had a multi-member LLC, the corporation owned 10% and I own 10%, or I own 90%. Well, in theory, that works. I've got a multi-member LLC because the corporation owns a little bit and I own a little bit. Well, that works. A one-legged stool works too. But a three-legged stool works better. Anytime you bring in outside partners into a couple, into a marriage, well, not in a marriage, but it doesn't work in a marriage, into a partnership. Anytime you're bringing 3 or 4, it's like adding 3 legs to a stool. If you want to bring in your brother-in-law for a reason, if you want to bring in kids or parents or something, it adds tremendous strength to that multi-member LLC. But yes, it does work with just husband and wife.
All right, thank you, Don. The next question is, what legal structure would you use if you were wholesaling a property, consulting fees only? And if you don't mind, I'll start this one and then I'll let you finish. I personally, for wholesaling, you're going to make a decent amount of money quickly without much outlay. Maybe you put a property under contract for $100, then you flip that contract and you make a $5,000 consulting fee. I love to see that done in a Roth because it's a way to grow your Roth IRA very quickly and you won't pay any taxes on that Roth IRA. Now there's other entities and Don can take those.
No, that's great advice. If you can't do it within a Roth, An S corporation works really well if you're dealing under about $100,000 in gains per year. If you're dealing more than that, I'd probably use a C corporation. That the advantages of an S corporation kind of go away. They're great for reducing self-employment taxes, but once you met the threshold of $112,000 in income for self-employment, you really want to look at larger pension plans. You want to look at other things that a C corporation would have some advantages for. So that's probably how. Again, I'd have to know more. At the summit, they can sit down and go over your particular situation and lay it out exactly. Those are kind of guidelines. I hope that helps.
Yes, thank you. We're going to take one more question, and then any questions that we don't get to, feel free to still send them, and we'll answer personally by way of email. So the next question is, so when I have a Wyoming multi-member LLC, can I put my Kansas single-member LLC inside of the Wyoming multi-member LLC?
Can I put what type?
She has a multi-member Wyoming LLC and wants to put a Kansas single-member LLC.
Oh, absolutely.
She has a
So Kansas.
Okay.
So I've got, in fact, with what's on the screen, let's say I've got a property in Kansas that's held in a Kansas single-member LLC. I would want that in Kansas so that I have standing in Kansas courts. I want to be able to evict a tenant if I want to. If the furnace blows up, I want to be able to defend myself in Kansas. The property is located there. I want the single-member LLC in Kansas. I would want, if I own a Tennessee property, I want that in a single-member LLC in Tennessee. If I own something in Florida, I want standing in Florida courts or California or wherever. So single-member LLCs are most often held in the state where they're located. But Kansas doesn't have great multi-member LLC charging protection. So I put that hub in a state like Wyoming or Nevada, or I don't know, something that has great charging order protection. Now, can Nevada and Wyoming be overkill for small investors? And the answer is absolutely yes. If you've got very little equity, I'm just starting out, keep it simple. We don't need a plus asset protection for small investors. But once I get into, this is a big part of my overall estate, or I've got a lot of equity tied up in real estate, almost always you're going to want to use a state with great charging order protection for that hub. So great question. I'm sorry I was not more clear on that issue with states. Yes.
Thank you, Don. We have one more question that I'm going to read just because it's a quick answer. Can the multi-member LLC have several independent self-directed accounts as the members? And the answer is yes, it can absolutely do that. Again, if you have more questions, certainly send them to us, and Don will get back to you by way of email personally. Thank you, everyone, for joining us on the call today, and we invite all of you to come to North Carolina with us next month. And then there's another one in Las Vegas that if you can't make it to North Carolina, what are the dates on the Vegas one, Don?
It is November 9th, 10th, and 11th. That also is a Monday, Tuesday, Wednesday class. But it's Las Vegas, and we're going to have a lot of fun when we get down there.
Very good. And as Don said, they are asset protection geeks and prepare to receive a lot of information, but you're going to really learn how to protect yourself, how to grow your wealth, how to help you from a tax standpoint. It's really an amazing event, and I'll see you there. I think the November event I'm coming to also might bring some of my staff. So we're excited, and it was Don worked out a deal with us where you guys can come for free. So we're really excited about that, and we look forward to seeing you. Don, thank you tonight for educating us on this very important topic, and have a good night, everyone.